Welcome to the Lawyering Peace interview series, where we explore the intricacies of negotiations, accountability, law, and diplomacy in peace processes. Join us as we dive into discussions with individuals who have played key roles as diplomats, lawyers, prosecutors, defense counsel in negotiating peace and justice. I'm your host, Dr. Paul Williams, the founder of the Public International Law and Policy Group, and the Rebecca Grazier Professor of Law and International Relations at American University. Now, in this interview, I am joined by my good friend, Professor Meg deGuzman. Meg is the James Beasley Professor of Law and the co-director of the Institute for International Law and Public Policy at Temple University School of Law. Meg is also a judge at the International Residual Mechanism for Criminal Tribunals, which carries out the residual functions of both the Rwanda and the former Yugoslavia tribunals. And she is a fellow member of PILPG as one of our senior peace fellows. Meg, welcome to the program.
Thanks so much, Paul. It's great to be here.
Now, in today's conversation, we will focus on the interplay between international justice and building a durable peace. I'm so looking forward to this conversation today, Meg. Let's kick it off with the first question of, you've written quite extensively on mechanisms of justice. What is your sense of the degree to which justice-based mechanisms are important for building a durable peace? And then, to what degree have they actually been successful at doing so?
Sure. Great questions. Let me first start by saying, as I always have to do, that I'm speaking in my personal capacity and not as a judge of the United Nations International Residual Mechanism for Criminal Tribunals. Second, I want to say that from my perspective, it's really important to first define what we mean by justice mechanisms. And I take a very expansive view of the term. So I'm thinking here not just of criminal courts, but of all the different ways that justice can be sought, including, for example, truth commissions, mechanisms for reparations, lustration, and traditional justice mechanisms such as the Gacaca in Rwanda or the Matu-Oput in Uganda. So putting that kind of broad definition of justice mechanisms out there, I think justice mechanisms are extremely important in situations where large-scale human rights abuses have taken place. And I think it's very hard to have a lasting peace unless those kinds of harms that people have suffered are acknowledged and in some way addressed. Of course, that begs the question of how, which is why I think it's important to have that broad definition of justice mechanisms. In terms of the second part of your question, the degree to which justice mechanisms have been successful in supporting peace, I think it's really tough to answer because it's akin to the question of whether criminal laws or criminal enforcement in general functions as deterrence, for example, right? It requires analysis of a counterfactual situation, right? What would have happened in the absence of the justice mechanisms that we ended up using in a given situation? So I think while it's difficult to evaluate, there are, on the one hand, we can say that lasting peace has been elusive in many parts of the world, even though there have been justice mechanisms, right? That's clear. On the other hand, I think there have been situations that could have involved recurrence or greater recurrence of violence in the absence of the justice mechanisms, although I couldn't prove it, right, empirically. So I'm thinking here of, for example, South Africa and the Truth and Reconciliation Commission, which has been lauded and also criticized. And yet, would South Africa have been a more conflictual place in the absence of the TRC? I think there are decent reasons to believe that the answer to that is yes. We might similarly speculate about the ad hoc tribunals for former Yugoslavia and Rwanda. Those situations are by no means perfect. Those countries, certainly still face really significant challenges. And I think we can also at least hope that the justice mechanisms that took place in those situations had positive impacts on the degree to which they experience peace.
Okay, so on the whole, you're optimistic or positive in the role that justice has played in building a durable peace.
I think that's fair to say. I'm an optimist by nature, so we have to take that into account as well. But yes, I think it's fair to say.
Okay, well, let's explore this a little deeper. I oftentimes say that these mechanisms of justice, and in particular those relating to accountability, like the ad hoc tribunals or the International Criminal Court, are like 300-pound adolescent gorillas sitting on the pathway to peace. They're important, they're heavyweights, they're unpredictable, and mediators have to deal with these, or diplomats have to deal with these 300-pound gorillas of justice as they try to navigate the pathway to peace. What are your thoughts on that?
Yes, I have heard you say that in situations in which we've worked together. And I can certainly understand, particularly why you feel that way as somebody who has been so deeply engaged in so many peace negotiations. And I also agree that justice mechanisms carry heavy weight in peace processes, that there has been a real move toward the idea that there can be no lasting peace without quote unquote accountability, right? And I put that in scare quotes because, again, does that just mean criminal accountability, or is there a broader conception that can be brought to bear? I think there's still important debates to be had about that. So I think it is an important consideration, and one that can feel to negotiators like it's in the way, as you suggest. At the same time, I think that the predictability is increasing somewhat over time, right? Because now we have, for example, the ICC, the International Criminal Court, that has behaved in a certain way over a number of years, which is not to say that the behavior of the ICC is 100% predictable. Of course, it's not. Prosecutors change, policies change, and so forth. But I think that as the court's work progresses, there is an increasing level of predictability that can be brought to bear in peace negotiations. Now, of course, that applies in particular in situations where the ICC has jurisdiction, less so in situations where it doesn't. And then there are questions about, should an ad hoc or some kind of special accountability mechanism, whether it be criminal or otherwise, be set up, that I think, is less predictable perhaps than the ICC might be. So I basically agree with you. I think, though, over time, this regime is developing, and it's still quite a new regime, right? If we think back to the 80s and 90s, we didn't have these mechanisms. We didn't have, or we were just starting to get the mechanisms in the 90s, post Nuremberg mechanisms. So I think there is an increasing level of predictability, but it remains certainly a question mark what's going to happen if an institution is set up, for sure.
So it's an adolescent gorilla that's becoming a little more mature and a little more predictable as it.
Fair. Yes, I like the adolescent part of the frame.
As a mom to teenagers and as a dad to a former teenager, we can relate. Let's talk about the International Criminal Court and your perspective from the Rome negotiations. You were there in Rome when they were negotiating the statute for the International Criminal Court. You were the legal advisor to the government of Senegal's delegation to the negotiations. At the time, were people thinking about the role of the court in building a durable peace, or how the actions, the indictments, trials of the court might impact peace negotiations? What was the vibe like?
Yeah, let me first start by saying that it sounds very grandiose to say that I was the legal advisor to the Senegalese delegation. I was a law student who was graciously given a title of a legal advisor, but basically I was a glorified note taker in Rome. So I just want to be humble about that, first of all.
Meg, it's still very impressive as a law student being on a delegation at the Rome statute, making history.
Well, it was a lot of fun. It was really, really interesting. I had actually lived in Senegal, and so it was a nice fit for me to be able to be on the Senegal delegation. So I have general familiarity with the negotiations. I wasn't particularly focused on this issue, so I can't say a lot about the specifics about what took place in the meetings, but I will say a couple of things. First of all, the focus of the negotiations was on essentially developing a statute that states could support, or in some cases, at least not get in the way of, right? So the focus was really on the nuts and bolts of the different provisions. It wasn't as much an exercise in big picture thinking, which in some ways, people looking back have lamented and said, maybe there should have been more big picture thinking before or during the process of setting up this court about what the role of the court would be in the world. Instead, it was largely a question of, putting together the articles that would delineate the subject matter jurisdiction, the admissibility, and so forth, and then hoping that the court would get up and running and figure out the rest of it once it did, right? And to be honest, and I think a lot of people who were there at the time will say that there was not a very high degree of optimism that the court would actually get up and running at all, right, in our lifetimes. It seemed like a wonderful thing to get the statute passed, and yet, people were not at all saying that it would become a living, breathing institution in just a few years. So with all of that said, the questions about the relationship between the court and peace negotiations came up in the context in particular of Article 53 of the Rome Statute, which is a provision about when the prosecutor can initiate investigations. And it says that the prosecutor can decline to initiate an investigation if he or she determines that it would not be in the interests of justice. Right? This is the famous interests of justice provision of the Rome Statute. And as I recall, one of the driving forces behind the adoption of this kind of carve out or opportunity for the prosecutor to say, nope, I'm not going to go down this road, was the South African delegation, which was thinking about its own process that didn't involve criminal accountability, or at least didn't involve a lot. It wasn't the main focus of the transitional justice process in South Africa, and felt that there should be some opportunity for the court to, allow for that kind of situation in the future. What's interesting, though, is that the prosecution has largely stayed away from this provision, right? They have not invoked it to explain why they were not going to go down a particular situation. And the one thing that they have said in a policy paper is that the interests of justice are not the interests of peace, right? They've specifically said that it's not their job to think about what's in the interests of peace. Their job is to think about, are there crimes being committed within their jurisdiction, and are there people who, should be prosecuted for those crimes, and so on. So in that sense, I would say, the actors at the court that I've talked to about things like this tend to feel that they should stick within their kind of criminal law mandate and not think about these bigger picture, they'll often term them sort of political questions, that those should be sort of for other people to think about, and that the court should, and makes a lot of sense from their perspective why they would want to do that, I think.
Well, Meg, I remember those conversations at the time, and you're right, there was a serious doubt that the tribunal would actually get up and running. So as you say, there was not a whole lot of consideration given to the impact of the tribunal. Folks were just hoping that they designed one that was functional and somehow it would get ratifications and it would get funding and it would be up and running. But it was on the fast track. And not only did it get up and running quite quickly, it then started indicting heads of state. It indicted President Bashir of Sudan and continued on that path, and more recently indicting President Putin and Prime Minister Netanyahu. It's literally, in the fast lane of justice. Was there thinking at the time that that's what the court would be doing? And if so, were the countries comfortable with that? And if not, do you think in hindsight they would have adjusted the statute or maybe provided a few additional safeguards for heads of state?
I do think that that was envisioned by many delegations. I think many delegations thought that if heads of state are committing, ordering, supporting war crimes, crimes against humanity, genocide, and aggression, then they should be brought before an international court. And I think there were also delegations that were very much wary of that kind of future. I think it's certainly one of the reasons that the United States fought so hard to have the Security Council have a very dominant role in determining what situations would get before the court, right? So that the most powerful states, in particular the United States, would not run the risk of seeing their head of state, under an arrest warrant by the court. I don't actually know that it would have changed much if there had been, additional focus on that issue, because I think the courts that supported establishing the court generally favored treating everyone equally. And they also thought, for the most part, or at least many of them thought, we have very good functioning systems that we're not going to be committing a lot of these crimes. And so our heads of state are not going, they didn't see themselves as potentially liable at the time. Now, of course, later we saw things like the ICC looking into whether to charge British soldiers involved in Iraq. I don't think that the UK envisioned that when they were negotiating the statute, right? They thought our justice system is going to take care of all these kinds of things to the extent that our nationals engage in them or they happen on our territory. So the ICC won't have a role with regard to us, right? But I think that there were certainly plenty of other states that thought, this should be created as a court that should in particular focus on those most responsible for the most serious crimes. And that would certainly include heads of state if they're supporting or ordering, et cetera, these kinds of crimes.
Okay. So those that were drafting the statute of the court and adopting it went in with eyes wide open about what it might do in terms of indicting heads of state and what it's done this last year.
Well, let me just say, I think it's very hard to generalize about this, right? Because
so many states have that.
Yeah. Lots of different states, lots of different perspectives, et cetera. I think that the political dynamics of, the Security Council and so on, the powerful states, many of them felt secure that this was not going to affect them, right? That this was going to be a court for places where, they viewed these kinds of crimes as being committed, which honestly, was informed by racist views of the world, among other things, right? That these kinds of crimes don't get committed in the developed global north, et cetera. So I think it's difficult to generalize because different states had really different perspectives, right? States from the global south, many of which supported the court, had different views as well.
No, that's an important point too. It was a very eclectic group, obviously, of states that were drafting the statute. Now, let's narrow into the Yugoslavia Tribunal. You spent some time at the Yugoslavia Tribunal as a young lawyer or as maybe a law student as well.
Just an intern. Yep, just an intern.
It's amazing internships early in your legal training. And Justice Goldstone is well known for, he was the chief prosecutor. He was appointed to the Constitutional Court of South Africa, played a role in their Truth and Reconciliation Commission. And President Mandela personally asked him on behalf of Kofi Annan to go and be the prosecutor for the Yugoslavia Tribunal. And he was well known and well respected for following the trail of evidence wherever it may lead. And during the Yugoslavia conflict, that trail of evidence led right to Radovan Karadzic, the political self-declared president of Republika Srpska, and Ratko Mladic, the head of the army in the Republic of Srpska, both of which were responsible for atrocity crimes and genocide. So he indicted them. And this occurred when Dick Holbrooke and Carl Bildt were doing shuttle diplomacy around Yugoslavia, trying to get the parties to agree to, come to negotiations. It ended up being being at Dayton. And Goldstone just indicted, two of the key players that many people assumed and or feared would be at the negotiating table. What is your take and your perspective on that, knowing Goldstone then and now as you do, and knowing the work of the tribunal and the impact of the tribunal?
Yeah, I mean, I was not surprised at the time. I was actually in law school. One of the other things that I did was I was part of a clinic that was suing Radovan Karadzic under the Alien Torts Claims Act. So I had spent a good part of my law school career, basically writing up the facts of what Radovan Karadzic had done and, putting those in terms of international criminal law and all of that. So the idea that those two, war criminals would be pursued by Justice Goldstone seemed entirely logical. And I think that in that period in particular, there was a sense that international criminal law was kind of the solution, or really there's just a lot of enthusiasm behind it, right? It was the first time since Nuremberg that a tribunal had been set up, ostensibly on behalf of the international community to prosecute people at that global level. And so I think, there was a lot of enthusiasm for this concept that peace and justice have to go hand in hand, right? That you can't have peace without justice. In fact, the organization that I worked for in Rome, when I was, matched with the Senegal delegation to provide them legal advice, was called No Peace, is still called No Peace Without Justice, right? That's the name of the organization. There can be no peace without justice. So it was an era of great optimism about the potential for international justice to promote peace, and also a time when people were thinking that it was a requirement of international law that people should be prosecuted when they commit these kinds of crimes. So I was certainly part of that movement. I think my perspective has broadened over the years, and we can talk more about that if you like. But I was at the time very much bought into this idea that it was important to prosecute, as many people as possible who had committed these kinds of crimes.
Well, let's dive into that with a bigger picture question. You've seen the work of the Rwanda Tribunal, the Yugoslav Tribunal, the Sierra Leone Tribunal, the International Criminal Court, and by and large, they've followed the evidence trail, and they've indicted those that are responsible, or there's a prima facie case for believing they're responsible for atrocity crimes. Has this in fact promoted a more durable peace?
Yeah, so that's sort of similar to the question that you kicked off with, I think is a really tough one to answer, because again, we're talking about the counterfactual, right? What would the situations have been like had there been no Yugoslav Tribunal, Rwanda Tribunal, ICC involvement, etc. So in a way, I would say it's too soon to answer this question, or at least, again, being the optimist that I am, I would say I'm hopeful that it will be easier to answer this question with a greater degree of confidence looking back, a few decades from now at some of these mechanisms, because, like the gorilla you talk about, this whole system is adolescent. And in order to evaluate its impact on peace, I think you need a lot of data over a long period of time so that you can make some generalizations despite the fact that you're dealing in counterfactuals. I also think with regard to the ICC in particular, it's very difficult to measure the ICC's impact because not all of what the ICC does is visible, right? So the ICC is visible in certain situations, and those are the ones that get talked about and that get debated in terms of the impact on peace, et cetera. But there are a lot of other situations where the ICC is working behind the scenes, right? In line with this idea of what they call positive complementarity. Right? So complementarity is the idea that the ICC is not going to get involved in a situation if there is a national system that is genuinely investigating and prosecuting the crimes that the ICC would want to investigate and prosecute. In addition to that, the ICC has taken this perspective that it can engage in this positive way with states, helping them down the path of doing these kinds of prosecutions by, sharing expertise, possibly sharing evidence, things like that. And so in those countries where there may not have been, a recourse to violence as part of working through domestic prosecutions, we may not kind of give credit to the international system. And yet it could be very, very important the way that the international process is working in the background. So I realize I'm not giving you a very direct answer to the question, but I think it's A, complicated, and B, one that really will have to be looked at in a very long-term way to have any degree of confidence.
Well, let me loop back a little bit to your comment about maybe your view on following the evidence where it may lead may be more comprehensive now than it was earlier in your career. What is your take on following the evidence where it may lead, indicting all of those who are responsible? Should prosecutors have a little bit of a political lens or a political tint, or should they just follow the evidence where it goes, regardless of potential political consequences or potential impact on a peace process?
I think it's important for prosecutors to be aware of the context in which they're operating. So, prosecutors tend to be allergic to the word political, and understandably so. I think a lot of their legitimacy is linked to the idea that they're just staying in their zone. And at the same time, I do think that they should be and are, despite, maybe not putting it in this kind of language, aware of the political context in which they operate. So, for example, there have been some international prosecutors criticized for not indicting people on both sides of a conflict when both sides have committed, international crimes. And it seems pretty apparent from the outside that they likely did that because they wouldn't have had the cooperation they needed to get any kind of justice in the situation if they had indicted people on both sides of the conflict. So then the question arises, okay, well, that's not fair. That's, not conducive to high levels of legitimacy in a sense. And is it better than nothing at all? That's where we have to argue, right? That maybe it is better to have had some justice in the situation if the alternative was not to have any, even if it was imperfect justice. So that's a question that I often ask when I'm thinking about the degree to which, political considerations, I think, inevitably are going to come into these kinds of decisions, whether it's acknowledged or not. And I think that that's the nature of the system is such, right? The international criminal justice system is embedded in a broader political structure of vastly unequal power and, prejudice and resource differentials and all sorts of things, right? And so that inevitably is going to affect the way that the system operates. So I think we have to be realistic about that. And while it's important to, criticize and to argue for courts to do better and so on, I also think we have to be understanding of the context in which the courts are operating.
So let's talk about that context a little bit, but shifting gears to into peace negotiations. For many, many, many decades, if not centuries, we operated in an age of impunity. Atrocity crimes were the norm. People would get together and they would grant amnesty to each other as part of the peace negotiation. And then you had the 90s, where they were still trying to do that, but you had a Yugoslavia tribunal where Goldstone basically plowed ahead. You had the Sierra Leone Lomé Agreement, where there was an amnesty which was granted, and the Sierra Leone tribunal said, yeah, well, we don't care. We're still going to indict you. And there's now a growing sense that we're into an age of accountability, and that it's no longer appropriate or accessible to get together at a negotiating table and pen out a paragraph on amnesty. Now, I put this question to every guest that I've chatted with on this Lawyering Peace podcast, and they're split pretty much 50-50 on whether we are in an age of accountability and whether we're going to stay in this age. What are your thoughts on that?
So I think it's a fascinating question, and it's one that I would say I think about quite a lot and devote a decent amount of my scholarship to in one way or another. I think we have to start by thinking about what we mean by accountability, right? As I said before, are we just talking about criminal accountability? And I think, I mean, correct me if I'm wrong, but for these purposes, I think you're talking about criminal accountability, right?
Yeah.
And
Holding the leadership responsible for their atrocity crimes.
yeah, for their atrocity crimes, right? So that's the other thing that we have to think about. What do we mean by atrocity crimes? So generally, people are talking about a narrow band of crimes that fall into these specific categories of war crimes, crimes against humanity, genocide, and aggression. And it's clearly the case that for some of these crimes, some of the time, against some people, the international community now doesn't accept impunity, right? But it's not the case that all of the time for all of those crimes against all people who commit them, the international community doesn't accept impunity, right? So if we're in an age of accountability, it's clearly partial accountability, right? We're not still seeing prosecutions, despite, some move in this direction of, arrest warrants against powerful leaders of powerful states. There are still lots of leaders who are not being indicted, who are committing these kinds of crimes. Then there's just a lot of issues with this age of accountability idea, right? So if we think about the global power dynamics and how they influence who gets prosecuted, for many years, the ICC was prosecuting just African defendants, right? And that became very controversial. The court was accused of neocolonialism, with really good reason. And at the same time, the court said, well, a lot of these cases were self-referred by the states involved, right? These were cases where the states were saying, come, we'll cooperate. We'll give you evidence, we'll let you in so you can get evidence and so on. But the perception was that it was accountability by powerful global North states against, weaker, mostly African states with this undercurrent of or sense of neocolonialism and so forth. So that has gotten better in recent years. That sort of perception, I think, has been eroded to some extent by these more recent arrest warrants against Putin, now, et cetera. And yet, the actual cases that the court has been able to adjudicate are still mostly African against African defendants. So that issue still remains. Another big issue with calling this an age of accountability has to do with the way that atrocity crimes are constructed, right? We're generally focusing on this very narrow band of crimes that occur mostly in armed conflict, situations of violence, sometimes in situations of dictatorship and so on. But these crimes, basically, the way they're currently structured, are crimes where the harms are first highly visible. And Randy DeFalco wrote a really interesting book about this recently. We're talking about crimes that sort of assault the senses in a way, but then we're ignoring or, failing to surface the underlying structural violence that often has actually been the real cause of the violence that led to the crimes, right? So if we're talking about North-South extraction of resources, if we're talking about corporate greed, that is causing, so there are a lot of these underlying structural causes that are not currently captured in what we think of as atrocity crimes, for which there's no accountability and no hope of accountability. So again, sort of, yes, there is some sense in which there is more accountability than there used to be. And yet it's very selective, very partial, narrowly defined crimes. Some of the harms that are sort of the most dangerous to our very existence, like environmental harms, are currently not captured, or captured in a very kind of minimal way. And there are conversations about, should we add ecocide to the Rome Statute and so on. So I could go on about this, but I think my basic message is that yes, there's some accountability, and also generally, as an optimist, I think that this is a positive development in some ways. And there's also a lot of work to be done to ensure sort of broader based accountability. And then I'll just also footnote that the accountability that we have is also some ways, instantiating some of the norms that cause some of the harms. I'll just give you one quick example. Rachel Lopez and I just wrote a book chapter on the extent to which international criminal law is feminist. And we cited a lot of feminist thinkers talking about the ways that some, norms that harm women are actually reflected in the way that international crimes get prosecuted, or in the institutional dynamics and so on. So it's not all a rosy picture, right? So if we say age of accountability and we're thinking of that as a positive, there are a lot of caveats and nuances that we need to take into consideration.
Well, Meg, let's continue on this conversation of arcs as they relate to justice. We just talked about the arc of moving from an age of impunity to, I guess we have to use a few more words to describe what we're in now, the age of partial accountability, which may be imperfect, but is at least heading in the right direction. Now, Meg, you co-edited a volume, Arcs of Global Justice, which was a series of essays in honor of our good friend, William Chavis. And the series of essays explored the myriad ways in which justice has developed over the last half century. Where do you see some of the various arcs of justice taking us into the next half century?
Yeah, I think my thinking has evolved significantly since that particular project, in that now I think that there needs to be something of a correction of the direction that we're going in, right? I think that the arc has tended to push very strongly in favor of just criminal accountability, and criminal accountability for just these particular narrowly defined crimes. And I think that now there's an increasing recognition that that push toward that particular kind of accountability has been a bit strong, and that now we need a correction. So people are increasingly writing about this. There have been some recent essays in the Journal of International Criminal Justice, for example, talking about, the sort of critiques of international criminal justice and what can be done productively from here to sort of help to correct the system. And it's something that I'm thinking about, and sort of a direction that I'm taking in my scholarship is to think about what that can and should look like. For me, it involves going back to ideas that were somewhat more popular, 20-ish years ago, about having a more pluralistic approach to justice after periods of massive human rights violations. So thinking more, because we still have a field of transitional justice and I used to teach transitional justice, that considers lots of different kinds of mechanisms as important in helping to address harms in the wake of conflict or dictatorship. And that field, even the field itself, I think has shrunk and gotten a lot less attention than it used to get, because there's just so much focus on criminal accountability. The example that comes to mind when I sort of want to illustrate this point is how quickly after Russia invaded Ukraine, people were calling for prosecutions. It was like days, right? Almost maybe even hours, right? And which is not to say that there shouldn't be criminal accountability there, but there are going to be a lot of needs related to justice beyond criminal accountability. So it's not, I guess, as clear to me as maybe it once was that so much focus and so many resources should be going into thinking about criminal accountability specifically, right? So I'm hoping that this arc is going to lead toward a broader understanding of the kinds of justice that are needed in situations of, again, mass human rights violations or structural violence and things like that. And that, more resources will be put into thinking about those broader based kinds of justice initiatives. Philip Alston just wrote quite a good short article about this that talks about how sort of strongly we've moved in the direction of criminal accountability and how we need to sort of rethink this. And that's basically what I've been thinking as well. Thinking about things like reparations, for example. People are starting to think more seriously about reparations, including for structural harms, even, historical kinds of harms. And that, I think, is where the arc really needs to go.
I think, Meg, what I've seen is there's a snowballing effect. Whenever I work in a post-conflict country and there isn't a mechanism of justice, the question that civil society, civilians will ask is, well, the Yugoslavs had accountability, the Rwandans had accountability, the Sierra Leoneans had accountability. Why don't we have accountability? It's that first, as you say, within hours, within days of a situation, people expect that the global community, especially since there's an international criminal court, should be finding a way to move in the direction of criminal accountability. And that snowballing has crowded out, as you say, reparations, truth commissions, other mechanisms of justice. Let me pivot a little bit back to peace negotiations. And this is a question that I've been asking my guest recently. In a peace negotiation, do you ever foresee the legitimate possibility of an amnesty? In today's partial era of accountability, do you foresee circumstances where parties get together and, you might actually want to weave an amnesty for atrocity crimes into this peace agreement to get to yes, and it might actually help build a durable peace?
Yeah, so I have always been in the camp that William Shavis, who you mentioned earlier, and also a friend who's a scholar who wrote an article about this years ago, Ron Sly, who've had a more nuanced view than the sort of no amnesty can ever be legitimate for these kinds of crimes. I think it depends on the kind of amnesty. In particular, are we talking about amnesties for the top leadership who are most responsible for setting in motion the sort of systems and methods of warfare and so on that caused the greatest damage and so on? That, I think, is more problematic than if we're talking about amnesties for those who carried out the orders on the ground, who may have had, been acting to a significant degree under duress and so on. So, saying that there can never be amnesty for an international crime, I think is too broad a statement. I think the Colombian peace process, is providing an interesting example of how there can be alternatives to criminal punishment even for war crimes, particularly when people are willing to take responsibility for what they did. And then in Colombia, they're, I think, engaging in some innovative thinking about alternatives like community service, right? Like reparations, things like that, that can be ways of helping to restore and provide justice while not necessarily doing it through criminal punishment for some kinds of people who have engaged in international crimes.
Well, Meg, thank you for your time this last hour. It's been really exciting to speak with you and to hear your thoughts. One last question. Key takeaway. A number of our listeners are young professionals looking to embark on a career either of conflict resolution, building durable peace, accountability, or transitional justice. What is the one thing that you want them to take away, to remember from this conversation or from your life experience working in this field?
So first, let me thank you for including me in this series and engaging in this really interesting conversation with me, and also for your incredible work through PILPG in helping to negotiate peace around the world. I'm constantly impressed by the work that you and the other PILPGers do. So it's an honor to be associated with all of you. In terms of a takeaway, I would say, you know, think deeply about what justice means and think about it from as many perspectives as you can, and think about it while, thinking about your own life experiences, your own context, and then go and find out what other people think about it. Right? I think that there's been a way in which a certain group of people at the international level, or people who are engaged in international affairs and international law, have come to have a relatively narrow way of thinking about justice. And I think it's time to correct that, right? So I think it's time to do more inquiry about what people around the world want in terms of justice before coming to a proposal about how international resources, international expertise will be used to facilitate justice, right? So doing more listening, more investigating about what is needed, what is desired in a particular situation before starting to build a plan, right? Trying to avoid sort of path dependencies and assumptions that have built up over time about what people want and what justice means. And really trying to open up this question and think about it broadly and deeply as we continue to think about how best to use the global community's resources and these bright minds that are coming into the field, using their time and expertise to best help to ensure lasting peace and global justice going forward.
Well, Meg, I think our young professionals will definitely take that advice to heart. And I think some of our senior professionals who are listening also, it's time for all of us to refresh our perspectives. We tend to figure out the answers and know what's right, and narrow our perspective. And so, Meg, that's a really good reminder that we should be constantly refreshing our perspectives and rethinking things that we already know. Meg, I'm so grateful that you spent this last hour with us sharing your thoughts on the durability of peace, the role of justice. It's been a real honor and privilege to have this conversation, but also to be friends and colleagues over so many years together. You're one of those unique individuals who is engaging in phenomenal scholarship. If someone wants to know something, I would say, go read Meg's work. And then also your activities in the field, starting from when you were a law student in Rome and in The Hague, you've always had a hands-on experience with justice. And that's really does reflect into your scholarship, and your scholarship reflects the work that you do and that so many of us do as well, based upon your principles and your thinking. Thank you, Meg. This was a real pleasure.
Thank you so much, Paul. The respect and admiration are very much mutual, and I really enjoyed the conversation.